come up. Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning. We're pleased to welcome counsel and all those watching on our Supreme Court Live channel as we start this September docket with the morning cases. I will ask Mr. Doug Shima to please call the first case of the morning, please. Mr. Shima, you're muted. Hey, I'm not sure what's happening, but we will proceed and I will call the first case of the morning. I'll call case number 120434, State of Kansas versus Dwayne Lynn Patton. Counsel, would you please state your appearances?
Thank you, Your Honor. May it please the court, Shannon Crane representing Dwayne Patton. I am present and ready for argument.
May it please the court, my name is Thomas R. Stadden. I am the Reno County District Attorney on behalf of the plaintiff, State of Kansas. I am present and ready for argument.
This morning, we have a change of the makeup of the court for this case because Justice Standridge has recused. In her place sitting today, we have Judge Henry Green, who is the longest current serving judge on the Court of Appeals of our state. Judge Green has served on that court since 1993. Judge Green, we thank you very much for bringing your time and energy and expertise to help us resolve this appeal. Thank you.
Thank you, Chief.
With that, Ms. Crane, you may begin your argument.
Thank you, Your Honor. There were two issues raised in this appeal. I'd like to focus on the second issue regarding the DUI statute, and I would present my issue on prosecutorial misconduct on the brief. A brief statement of the facts. Mr. Patton was charged with a DUI in Kansas in 2016. He was convicted and sentenced in 2018 when he was charged with a fourth or subsequent DUI. The PSI showed that he had several DUIs in his past, including a 2003 Oklahoma conviction, a 2007 Missouri conviction. He also had two other Kansas convictions, one in 2003 and one in 2007. The issue today is which law should apply in determining whether the out-of-state convictions should count to enhance his sentence. The DUI law progresses. With each one you get, the punishment becomes more severe. I submit that he was, the time of the offense, which is 2016, should be the law that applies in this case, not the date of his sentencing or his conviction and sentencing. The Court of Appeals, in its decision, held that the state and I both were wrong in saying that the 2016 law should apply, and held that the 2018 law should apply. Mr. Patton was sentenced as a fourth time or subsequent DUI. He was sentenced to 12 months in jail and was given a $2,500 fine. That is the maximum or the minimum for a fourth. The state has argued that it really doesn't matter whether it was 4 or 3, that the sentence would have been the same, and we don't know that. He could have been sentenced to a lesser fine had this not been his fourth conviction that counted. So with that, I believe the Court of Appeals erred in two ways. First, I believe that the 2016 law should have applied. At that time, the 2016 law required that any out-of-state conviction had to have the same or narrower elements as the Kansas law. It was a comparison of the elements between the two states, but they had to be the same or narrower. And both the Missouri and the Oklahoma laws are broader in scope than the Kansas law. You can be convicted of other things under the DUI statute that you cannot be convicted of in Kansas.
Ms. Crane,
Yes.
can when I read the briefing, it sounds to me like your argument is the pre-amended statute applies under rules of statutory construction. It does not appear that you're raising or briefing an ex post facto challenge here. Is that correct?
That's correct. I did not brief that. The statutory construction, the date of the offense normally applies to what law you use at sentencing, and in this case, that's in 2016, not 2018. One of the reasons that the Court of Appeals stated that it should not apply is because the DUI statute is a statute into itself. It doesn't have this. It doesn't have the same rules as the Kansas sentencing guidelines. It's self-contained, and the rules that govern the felony sentencing guidelines don't have to apply to a DUI. And that might be true, but it doesn't mean that nothing under the Kansas sentencing guidelines applies. It says some things do not apply. And in this case, I believe that the time of the offense was committed should be the law under a DUI as well. The Court of Appeals relies heavily on Reese, State v. Reese, in making this determination. That was a case where the Court of Appeals, I believe it was the Court of Appeals, stated that you count how many prior DUIs they have at the time of sentencing, not at the time of the offense for which you're being sentenced. And the Court of Appeals used that reasoning to say that's why you're going to look to see which statute applies, whether it's 2016 or 2018, and it should be the one at the time of sentencing. However, there's a big difference between making that determination that you count how many priors at the time of sentencing. You can get more DUIs in between the time you are arrested for the first one and the time you're sentenced for that case.
Ms. Crane,
yes.
I'm sorry to interrupt, but I had another question along those lines. So Reese applies its construction to a different portion of the DUI statute, but it does do a statutory construction and concludes that based on the language and viewing all the provisions together, that the legislature intended us to apply the law at the time of sentencing. I mean, why would that analysis change under a different, when applied to a different subdivision of the, or subsection of the DUI statute?
There are other situations where this sort of thing happens, and the law at the time of the offense does rule, and those two are possession of marijuana and driving while suspended, both of which use the other rationale in order to say you use the statute in place at the time of the offense. In fact, I had a case where a gal was convicted of DUI. By the time she got to trial, the law had changed. And we argued on appeal that she should be sentenced under the new statute, making that DUI not a felony, making it a misdemeanor. And the Court of Appeals blocked that and said, no, you use the law that was in effect at the time that she was of the offense. And the same thing happens with driving while suspended. At one point, they were felonies, and then they changed the law. And this is about enhancing the sentence. And again, it was the law at the time of the offense controlled whether it was a felony or a misdemeanor and prescribed the sentence for that. So those two things, I think, cut across State v. Reese to show that just because when you're counting how many you have and you use at the time of the sentencing doesn't mean that you use that time of sentencing for everything in that statute.
Ms. Crane, can I ask you a question? I noticed in your brief, you're saying that the 2018 amendments should not operate retroactively. So is your argument that the 2018 amendment should only act prospectively?
Yes, from 2018 forward.
And give me your reason why it should only operate prospectively.
The legislative intent, if they wanted to make it retroactive, they would have. And in fact, those two instances I just told you about with the driving while suspended and possession of marijuana, those were not made retroactive, and there was nothing in the legislative language to make them retroactive. The same is true on this DUI statute. There's nothing in the legislative language that would indicate that they intended for this to be retroactive.
I had a computer issue and I lost a portion of the argument. So forgive me if this is a repeat question when I was absent from the couple of minutes I was gone. Are you making any constitutional ex post facto issue out of in this? Seems to me that if we adopt Patton, adopt Reese dealt with actually the sentence was decreased as a result of that interpretation. This is increasing the sentence after the act after the act was committed. Do you have any concerns about that if we have the interpretation from that the state is advocating for?
I do have concerns that would violate ex post facto. I did not brief that, however, and did not consider that when I was writing the brief. But I do believe that you may be correct that a review of the ex post facto rules may very well state that Patton, if it was adopted, would violate those rules.
Ms. Crane, you said at the beginning of your oral argument that you were submitting the prosecutorial misconduct issues on the brief, and I'm looking at your petition for review, and I don't see any prosecutorial misconduct issues being raised. You specifically say the Court of Appeals erred in ruling the Missouri and Oklahoma prior convictions should be used to enhance the sentence and that the case law is inconsistent. And then your statement of the issues at the beginning of your petition for review, to me, read exclusively about the issue we've been talking about. So I just don't see what that reference was about.
Justice Biles, you are correct. I did not raise that on my petition for review, so I will withdraw that issue from consideration. I appreciate you pointing that out.
Well, it's one less thing.
Yes. If there are,
Ms. Crane,
certainly.
before, I know that we've taken some of your time here. So what I really want to know is if we did apply the pre-amended statute, explain to me your argument on why the Oklahoma statute is not identical to or narrower than the Kansas statute.
If I may look at my petition for review. Well, pardon me for the delay. I did not review that part of my brief.
Probably have the same question if you're opposing counsel. We could get to it in rebuttal if that's easier.
I believe it's because, excuse me, the Oklahoma 2002 DUI statute permits a DUI conviction based upon a finding that the driver was merely under the influence of alcohol, which they interpret to mean that the condition in which intoxicating liquor has so far affected the nervous system, brain, or muscles of the driver as to impair to an appreciable degree his ability to operate his vehicle in the manner that an ordinary, prudent, and cautious man in full possession of his facilities using reasonable care would operate under like conditions. My argument there is that it's different than the Kansas statute, which requires a showing that you're incapable of operating the vehicle in a safe manner, and that is caused by an impairment that is caused by drugs or alcohol. So I believe that the Oklahoma case or statute is broader than the Kansas statute, and that you would have to look at the facts of the case to determine whether the behavior that caused the conviction in Oklahoma would also cause the same conviction in Kansas. When you do that, you violate Apprendi by judicial fact finding after the fact. So that's why I argue that the Oklahoma statute should not apply in this case.
Ms. Crane, I was somewhat confused as to how you treated the August 2010 Kansas conviction, because you don't really mention that in your briefing. I assume you believe that that counts as a prior?
I don't believe that it. I don't believe it was scored on the PSI as a prior conviction. The 2003 one was scored, but the 2010 one was not scored.
Does that have legal significance that it's not scored that way on the PSI?
It does to me, because the person writing the PSI is the one who's investigating to look to see whether there's similar convictions. It very well could have been a conviction in which the defendant didn't have an attorney and pled guilty. And those do not count against your criminal history. You have to have counsel. There are other factors that they may be looking at when they're comparing the journal entries to see whether it's a conviction that should have counted. So I don't think we can just presume that the person writing the PSI forgot or made a mistake. I think we have to go with what they say in the PSI.
And there's nothing in the record that would help us unravel what might be going on there, I take it?
I don't believe so. I don't know if there was anything in the sentencing hearing that when that was discussed or not. So I can't answer that.
All right, thank you.
Mhm. If
Other
there are,
questions?
I'm sorry, yeah.
Uh,
If there are any
Alright.
other questions, I'll turn it over to Mr. Stanton.
Thank you, Ms. Crane. Mr. Stanton?
May it please the court. First of all, the state did under in its briefing include that 2010 conviction in its argument. The Court of Appeals suggested that it was not included, but I certainly did include it. And so did Ms. Esau when she filed the supplemental brief on the appellee. So that is in the PSI. Speculation as to what might have been going on there is great, but it is in the PSI as a conviction, and there was no objection raised at the time of sentencing to that conviction. So in the state's mind, that conviction should be counted as a prior because it clearly appears in the PSI and it received no objection. So the state stands by its argument that even if the court were to uphold certain aspects of the Court of Appeals opinion, this is still a third and therefore a felony conviction.
Mr. Stanton?
Yes.
Does it matter whether or not it was charged that way originally? Or are you suggesting that it's harmless because
I think it would be an issue if we charge less crimes. If we said this was a second and it turned out to be a third, I think that that's a problem with the complaint. If we say that it's a fourth or subsequent, which I think is how it was charged, the harm would be, there would be no harm to the defendant because that's a determination to be made later by the court. So I don't think under the circumstances it doesn't increase the crime or the penalty that it would be of any significance at all. Regarding
what about the argument that the fine would have been affected? That's what I understood Ms. Crane to suggest.
Well, I mean, again, that's speculation as to what the court might have done. But the fact that there is the penalties remain the exact same makes, as far as Mr. Patton goes, it makes it this kind of a non-issue. I think what the court is looking at here is how do we apply the law going forward? And it was strange to me to find the Court of Appeals, and remember, it's been a long time since I did a lot of DUI. I've been doing major crimes and felonies for a long time. I wrote this appeal at the request of Ms. Esau, and I did not include Reese in the original brief. I think that it would have been beneficial to the court had the Court of Appeals, when it decided to sua sponte apply an issue or rule on an issue that wasn't raised in the appeal, that it would send it back to the parties for briefing, because we would have been in a better position if we had briefed it. But looking at all the facts of the case, it's always been my concern and my belief that sentence is imposed based on what the sentence was at the time of the commission of the crime. The Court of Appeals in this case reversed or indicated that Wettrick should apply. And I guess the question becomes whether or not your decision, the Supreme Court's decision in Reese, indicating that this is a self-contained criminal statute, takes it away from that Wettrick decision, takes it out of the purview of Wettrick, because Wettrick was clearly an interpretation of KSA 216811E, not 1567. And I think one of the important, it's why it's so important that the court determined what the law was at the time, was because of the actual language of 1567 at the time. It prohibited acts in 1567. The statute says, refers to prohibits acts this section prohibits, and then goes on to say any law of another state which would have constituted a crime referred to in I-1 or I-2 is to be counted. It doesn't use the term comparable, identical, or any other such language. Wettrick was interpreting that term comparable. So if the 2015 statute applies, then we don't even get into the issue of whether they're comparable, because it uses a completely different standard.
What standard do we use?
Well, I guess you have to interpret what that language means. Prohibited acts, this section prohibits, and any law of another state which would constitute a crime described under those sections. So,
And by a matter of logic, is there anything other than a crime that would be identical to or narrower than? That would, I mean, that seems to me like that's a good definition of what that phrase that would constitute an offense could mean.
well, and that's true. And I guess that's for this court to determine whether that standard and that definition is also going to be applied to the language of the 2015 statute. If the court was correct, though, and this is an issue that we look at the sentencing at the time, we also look at the legislative intent. And clearly, the Court of Appeals was accurate when it cited the legislative history here. And the legislative history specifically notes the Missouri and the Oklahoma statutes as being comparable and to be counted as priors in Kansas. So if we're gonna go with the 2018 statute, I think we have to look at that and see if that's what the legislature intended, and it certainly was. Regarding the issue that the judge pulled or asked about as far as the Oklahoma statute, I addressed that in my original brief, and I think I addressed it on back here on page 13, and it's the state's position that that statute does apply to a conviction where a defendant is under the influence of any combination of alcohol or drugs which renders that person incapable of safely driving or operating a vehicle. That's 47 Oklahoma State annotated 11-902A. It's a 2002 statute. So I think the court was absolutely accurate in determining that was a conviction that should be counted. The state, in my original brief, I discussed the fact that the Missouri statute did look broader, because I was looking at Wettrick and after it applied, and so we conceded at that point that the Missouri statute was broader, and I'm not going to change that position, because if the court finds that Wettrick was properly applied, then I have to agree with my original logic on that. I guess it comes down to whether or not this court continues to indicate that Reese is good law. If Reese is not good law, then we will do something differently. But if Reese is good law and this is a self-contained statute, then the Court of Appeals should be upheld.
Mr. Stanton, in your supplemental brief, you seem to criticize the Court of Appeals for relying on Reese because you indicate that based upon Reese talking about the law in effect at the time of sentencing controls, that you believe this could be an ex post facto violation. I'd like for you to explain that and expand it, so I can understand your position.
Well, I think that if you look at Reese, and it's kind of the situation we have here, is that the law changed from the time of the commission of the offense, and then it is now being applied to the sentencing in this case. And so I didn't, as prosecutor, we didn't raise the constitutional argument, but I think it's incumbent upon us to discuss that when we're briefing it with the court. And I think there could be some ex post facto considerations because what if the statute makes it, what if the change in the statute makes it more, makes the penalty higher?
So if you're saying that applying a Reese and with these amendments, and it disadvantages the defendant or offender, then that gets in the area of ex post facto.
Well, it certainly could, because what we're saying is if every time we apply a sentence, we look at what the current sentencing laws are, then there's always the possibility of it disadvantaging a defendant. A lot of times it doesn't disadvantage the defendant, but I think that the problem comes in. It's always been the situation that we apply the law in effect at the time, and the reason for that ruling is that we want to avoid ex post facto considerations. So kind of looking back and saying, well, now we're going to start applying sentences that are in effect at the time of sentencing is problematic in that it could create a ex post facto situation, and that is what Ms. Natasha briefed in her supplemental brief to the court.
So, Mr. Stanton, if I could just follow up on Judge Green's questions, I want to try to summarize what I understand your position to be. Strikes me as it has some tension in it. I understand you to be saying, please apply Reese, because if you apply Reese, the state wins, but Reese is probably unconstitutional.
Well,
is that a correct summary of your position?
Well, my original position would be that we apply the law as it was at the time of sentencing, because I think that's what we should do.
We do with this. So ex post facto was not raised or briefed by the defendant.
Correct.
But the state has now raised it.
Well,
where does that leave us? And if you're going to raise the issue, it seems to me incumbent upon the state to actually take a position.
Well, based on my knowledge of the law and my experience, opposing or continuing to support Reese is very problematic. This Supreme Court decided this issue, and they decided it based on an idea that it was the DUI statute was its own sentencing statute. Somehow that was different than everything else that we do in the criminal law. Obviously, anytime there's a constitutional issue, this court needs to determine, and I would never argue for a position that would place a defendant in a situation where they were looking at a potential constitutional ex post facto application of the law. So,
and I'll just say I appreciate the integrity of the state in the sense of that you've just framed that as your obligation to the law that goes beyond this case. I want to drill down to that really concretely to what I think is the key sentence in Reese, in which this court said that, quote, when we apply the amendments to the sentences imposed after that date, it is a prospective, not a retroactive application. And to what Justice Rosen asked earlier, that Reese wasn't dealing with an increase in the punishment. It was dealing with a decrease in the punishment. Is it the state's position that that sentence I just read from Reese is at a minimum inaccurate when dealing with an increase in punishment?
Well, yes, Your Honor. That would be my position in this case. And the problem The problem comes in that, as you know, as I've seen over the years, the DUI statute, at one point, the penalties will increase and then they'll decrease. They'll go back and to determine what kind of prior convictions will apply, how far you go back, all the look back provisions, they change constantly. I think KSA 8-1567 is probably the most amended statute, other than maybe manufacturing meth, in the history of legislation. And so I think it's incumbent upon all the parties to come to a conclusion that no changes in the law should ever increase a defendant's sentence. I think that's the constitutional precept that we all live by.
Are there other questions for Mr. Stanton? Mr. Stanton, anything you would like to say to close out?
No, Your Honor, I do agree that the prosecutorial misconduct claim was not raised, but I also believe that the felony nature of this offense should remain. That's all. Thank you very much for your time.
Thank you. Ms. Crane, you reserve 3 minutes for rebuttal.
Thank you. I don't believe I'll need all 3 minutes, but one of the things that Mr. Stanton just said is that this is still a felony because of the three prior, or the prior Kansas convictions. I disagree that the sentence is the same in both. A third DUI that is a felony because you had one prior Kansas conviction within the last 10 years is sentenced as a third DUI, which the minimum fine is $1,750. A fourth time DUI or subsequent, the minimum fine is, I believe, $2,250 or $2,500. I wrote it down somewhere, but I don't see that. $2,500. That's a big difference. It may not be a big difference to a lot of people, but to defendants, the amount of the fine is part of the sentence and is it can be a really big issue. So I don't believe that this is harmless error. I believe that it does have consequences to Mr. Patton and other similarly situated defendants. So I'd ask the court to disregard that argument from the state. And then one last quick comment on ex post facto. I agree with Mr. Stanton on that and with the justices, because if you do apply the 2018 statute, because Reese took part of the statute and applied it prospectively, therefore everything in the DUI statute is applied retroactively. If you do that, you are increasing the penalties on an event that's already taken place based upon a new law, especially in light of some of the decisions that are coming out that are interpreting the new 2018 and 2019 versions of that statute. There was State versus Megia, MEGIA, which was decided May 22nd of 2020 by the Court of Appeals. And it basically, in my reading of it, says that any DUI law from any other state is going to be comparable enough to count in Kansas. And we're not going to have to worry about narrower or same as. As long as it's close, it's going to count. That would significantly increase the amount of out-of-state convictions that can be used. And so it would make things worse for the defendant and increase the punishment, which I believe is a violation of ex post facto. So with those comments, unless there's questions.
I don't see any. Thank you, Ms. Crane, and thank you, Mr. Stanton, for your arguments today. The court will take this appeal under advisement. At this time, we'll have a short break in the proceedings while the attorneys in this case are leave along with Judge Green, whom we again thank for his service on this case.
Thank you.
So Judge Green will be conferencing with us and participating through to the end of a decision in this matter. So
Okay, look forward to it.
thank you, Judge. We will now also add back in or bring in Justice Standridge, who will be hearing the second case, and we'll also bring in the attorneys on the next case on the docket. Now also add back in or bring in Justice Standridge, who will be hearing the second case, and we'll also bring in the attorneys on the next case on the docket.
Justice Standridge or Mr. Stolte, your mic is on from the YouTube.
I thought maybe you were just convinced I was a ventriloquist.
Is that better, Doug?
I think so. I'm not hearing the feedback right now. I think we're set, Chief.
Is Justice Stiegel? Okay. Great. With that then, Mr. Shima, would you please call the second case on the morning docket?
Thank you, Your Honor. The second case for the 9 a.m. docket is appeal number 122046, State of Kansas versus Jessica Lynn Myers, Johnson County, briefs both sides. The appellant, State of Kansas, has reserved 3 minutes rebuttal time. Your Honor, we're ready to proceed.
Thank you, Mr. Shima. Counsel, would you state your appearances?
Madam Chief Justice, and may it please the court, I'm Jacob Gonteski. I represent the plaintiff, the appellant in this case, the state of Kansas. I'm present and ready for argument.
Good morning, Your Honors. My name is Adam Stolte. I represent Jessica Myers, the appellee in this case. We are present and ready to argue.
Thank you, counsel. Mr. Gonteski, you may begin your argument.
Thank you, Your Honor. This case presents a clear, clean-cut, not fact-based, but legal question surrounding what constitutes a prior conviction in a DUI case in the state of Kansas. We are not dealing with any ex post facto concerns or anything that was presented in the previous argument in Patton, because what we have here is a very clean case that arose, both the offense date and any sentencing date arose after amendments were made to the Kansas DUI law in 2018. So the question for this court becomes, was the Kansas legislature effective in crafting their 2018 amendments to the DUI law in capturing out of state or out of jurisdiction prior convictions, significantly prior convictions out of the state of Missouri when they drafted those amendments in 2018? That's what the case boils down to. There was a jurisdictional hurdle that was argued by both parties, and the appellee had filed a cross petition for review on the jurisdictional hurdle that it argued the state faces in this case. And I'll briefly argue a portion of that before I move on to the meat of the argument concerning the DUI prior convictions. The jurisdictional hurdle that the appellee argues is present here and that should preclude review from this court on this case is that the state drafted this appeal as an interlocutory appeal, appealing the district court's suppression of evidence. The reason why the state drafted this appeal in that manner is because this case was charged as a felony driving under the influence charge. It was charged as such because the defendant, Ms. Myers, has 2 prior convictions out of the state of Missouri. And when that felony was presented to the district court, the defendant waived her right to a preliminary hearing, but then shortly after she filed a motion to strike the prior convictions, the 2 Missouri convictions, off of her record that would thus make this case a misdemeanor, if anything. The district court granted that motion, finding that there was a thick overlay of constitutional concerns and finding that the Wettrick definition of a prior conviction being identical to or narrower than was controlling here. When the district court struck those prior convictions, that left the state unable to prosecute this case as it was charged. It was charged as a felony. It was a felony by virtue of those 2 prior convictions. And without those 2 prior convictions, the case could no longer proceed as it was charged as a felony. The district court did not dismiss the case when it struck those 2 priors. Had the district court dismissed the case, the state would have appealed under a different prong of the statute, which allows the state to appeal the dismissal of a complaint. But because the district court did not dismiss the complaint, but rather only struck the priors but allowed the case to proceed, the state was hamstrung in being able to proceed on that felony. So that's the jurisdictional issue here. Either way, this issue should get reviewed by this court. It's going to crop up time and again. It already has in Patton and Mejia and others that are in the pipeline. Moving on to why this court should find the legislature achieved their stated objective in capturing Missouri prior convictions when it amended the DUI law in 2018. I'll walk this court through 2 avenues that you can get there. Either avenue will suffice. If this court finds that the amendments in using the term comparable, which was obviously the word that was very much at issue in Wettrick, if this court finds the term comparable to be ambiguous, as it was in Wettrick, then this court should look to the legislative intent. It should look to the motives the legislature had when enacting these amendments, because the cases from this court have said time and again, when a term or a statute is ambiguous, we look to the intent of the legislature. And the intent of the legislature could not be more clear in this case. They spelled it out in the preamble of the statute itself. In their words, they said this amendment shall be liberally construed to allow comparable offenses, regardless of whether or not those out of jurisdiction laws are identical to or narrower than the Kansas offense. Furthermore, they specifically stated in the preamble to the amendments in 2018 that the legislature intends to promote inclusion of violations of Missouri law, section 577.010. That's the statute at issue here. Ms. Myers' 2 prior convictions were under the exact language of that statute. And the legislature made clear in their preamble that they intend to capture those prior convictions. So in the event this court finds the term comparable ambiguous, the legislative intent removes all doubt as to what they meant when they drafted this amendment. But in the event that this court is prepared to read simply the plain language of the statute without having to resort to legislative intent, the plain language of the statute will also get you there to include the prior convictions. And it'll get you there because the plain language of the statute dictates as much. The legislature, when drafting these amendments in 2018, gave subsection J in the new statute, which set forth 3 factors a district court is to consider when it is examining whether or not to include a prior conviction as a conviction in a DUI case. And those 3 factors that the court gave to consider include the name of the out-of-state or out-of-jurisdiction offense. The name of the Kansas one is driving under the influence. The name of the Missouri law is driving while intoxicated. They're essentially interchangeable. There are some nuanced differences. And when you look at the second factor that this court is sentencing court is to consider when examining whether or not a prior should count as a prior offense in the DUI law, the second factor to consider is the elements of the out-of-state offense. And the question there becomes whether or not the out-of-jurisdiction offense encompasses similar behavior. If we look at the elements of the Missouri law that's at issue here, is a person is guilty under that statute of driving while intoxicated when they operate a vehicle in an intoxicated condition. In Kansas, the element is satisfied when they drive under the influence to an extent that they are either unable to safely operate a vehicle or under the influence to the extent that their blood alcohol level is above 0.08. Those elements are obviously not identical, and Kansas courts have already declared before 2018 that the Missouri law is broader than the Kansas law, meaning it prohibits more conduct than the Kansas offense. And because that Missouri law is broader or criminalizes more behavior than the comparable Kansas offense, the Stanley court held that you cannot count as a prior conviction a Missouri DUI in Kansas. It was that case, Stanley, and then the follow-up of Wettrick in early 2018 that spurred the legislature to act here. In direct response to Stanley and Wettrick, the legislature drafted these amendments that are at issue here that we're examining in this case. That's why they changed the DUI law and set forth these three factors. So we have the name, we have the elements, but then we move on to the third factor that a sentencing court is to consider. And that is whether or not the out of jurisdiction offense prohibits, quote, similar conduct to the closest approximate Kansas offense. There is no question that the closest approximate Kansas offense is clearly DUI, driving under the influence. So it becomes a comparison between the Missouri law and the Kansas DUI law, and whether or not that Missouri law prohibits similar conduct to the closest approximate Kansas offense. Note that it need not be an out of jurisdiction statute that prohibits conduct that is identical to or narrower than. The legislature specifically addressed that point in attempting to rebut and respond to both Stanley and Wettrick. That's why the legislature drafted those.
I take it from that comment that you read the and in J to not really mean you look at all three factors, or I mean well, let me say it this way: is your argument that any one factor, satisfying any one factor, is enough, or do you have to satisfy all three factors?
I believe it would sort of be a Justice Breyer totality of the circumstances test. I don't believe as though you have to satisfy all three. I believe this statute does satisfy all three, but I don't believe as though you have to. I believe those are the considerations that a sentencing court should examine when evaluating whether or not an out of jurisdiction offense is going to count. So in the event that we need all three, and I'm not sure which of these three Ms. Myers is even arguing do not apply, other than to simply argue we want to uphold the Wettrick identical to or narrower law and statute. And so when we examine elements, we can only do that if they're identical to or narrower than. But the legislature made clear that's not the intent, that's not the goal, that's not the objective of the amended law in 2018. So I would argue that the language of the statute allows a sentencing court to examine all three, that not all three are required to be present, but that in examining all three, considering whether the totality of those three point toward inclusion of a prior offense or not.
Counsel, in your view of your two options, which do you think fits better with the state of our current case law?
I believe as though probably examining the language of the statute fits better. And the reason why I would say that, and not the leaning on the ambiguity of the term comparable. The reason I would say that, Justice Biles, is that when Wettrick considered the term comparable, it did so in a bit of a vacuum because the statute did nothing to define comparable. The standard criminal history statute 6811 has no sub-provision that sets forth what is comparable with clarity and with precision. And so this court found in Wettrick that was ambiguous, looked to different dictionary definitions and found them somewhat competing and said that term is ambiguous, so let's look to legislative intent. The reason why I say I don't believe as though that approach is necessarily the best one in this case is because when the legislature drafted these amendments, it set forth a subsection, this subsection J, which specifically states, in considering whether or not a prior conviction is comparable, these are the three aspects a court should look at. And so I believe the legislature provided clarity to the term comparable when it drafted these amendments, such that the court need not resort to legislative intent. But in the event that it does, I believe the state still prevails for the reasons I set forth earlier.
But taking your better fit option, the plain language of the statute's the way I would describe it, that's where the Court of Appeals thought you ran into an Apprendi problem. So how do you address that?
The Apprendi problem is not, respectfully to the Court of Appeals in the ruling below, the Apprendi problem simply isn't present here, because the Apprendi problem arises when a sentencing court or a district court is examining the facts of a prior offense. Apprendi says that those facts not determined by a jury cannot be used to enhance a sentence. This amendment to the statute presented in 2018 presents no Apprendi problem at all, because when we look at those three factors set forth earlier, not any one of those three considers the facts of the underlying case. They only examine the existence of a prior conviction. And this court said in Ivory that the existence of a prior conviction is not an Apprendi problem. It is not of constitutional concern because it is merely the existence of the prior conviction here. When we look at those three factors that the court set forth, they don't present an Apprendi problem because they're not fact-based at all. Any court can do the examination by looking only to the Missouri law 577.010 without any consideration to the underlying facts of Ms. Meyer's prior offenses. In fact, when we examined this case below, the facts of her prior convictions were never at issue or never raised and never discussed on the record for the very reason that we don't want them to be, because examining those facts presents the Apprendi problem. But when we're only comparing the out of jurisdiction law to the Kansas law, where it's simply a legal question and not a factual one, the Apprendi problem is simply not present. And that's where I believe the Court of Appeals erred.
Then what becomes the difference between the second factor and the third? As I read the second factor, it's the elements of the offense, and then the third is sort of something else. And I'm not sure what the something else is. And that's where the Court of Appeals got hung up. Now, I'll grant you, the Court of Appeals didn't cite any statute or case law that said the third factor created an Apprendi problem. It just announces it. But setting aside the analytical weakness of that, from an interpretive standpoint of the statute, it seems like we're saying 2 and 3 are the same thing.
They are very similar, Justice Biles. I believe my response to that would be the second one is examining only the language of the elements themselves, whereas the third one, I believe, is more broadly attempting to demonstrate that a district court should not only look at word for word the elements and make sure that they match, but the legislature, in setting forth that third provision where it says whether it prohibits similar conduct, I believe that is the clarity, the plain language in which the legislature was saying it need not be a perfect match between the elements. It simply needs to be similar. Whereas the element only test of subsection 2 would presumably be precisely what we had in Wettrick and Stanley, an element only comparison. The legislature was saying it's not simply a perfect match that we're requiring here. We're simply requiring something to be similar. We're still never delving into the facts. We're not getting into the facts of a prior case. And that's why Ivory controls over Apprendi in the scenario to demonstrate no constitutional concern here. I hope that resolves the question you had between the second and third factors. Realizing that my time is up for this portion, I will hold on to whatever rebuttal time I have remaining, but I'll ask that this court reverse the Court of Appeals that this court find conclusively that the amendments in 2018 were effective in capturing Missouri prior offenses in the DUI law. I'm happy to answer any questions this court may have.
I see none. Thank you, Mr. Gonteski.
Thank you.
Mr. Stolte?
Good morning, Your Honors. Judges, we disagree with the jurisdictional analysis below, but we agree with the Court of Appeals in Myers on the merits of the scoring of the out-of-state priors on this one. I can briefly touch on the jurisdictional issue. Judge, an interlocutory appeal under 3603 requires either an order quashing a warrant or an order suppressing evidence, a confession, or some other sort of omission. The Court of Appeals in this one added a designation, which is substantially appeared a felony designation. They said that that's okay, but that's just not in the statute. Because of that, this court does not have jurisdiction to hear this issue based on the ruling in State v. Masterson, which says that this case is, or that a prior conviction is not an element of DUI. With that, Your Honors, I'd move on to the merits of the issue.
Let me stop. Let me stop you there, counsel. On your motion, you filed a motion to strike. What were you trying to strike?
So, Judge, I was not defense counsel on this, but a motion to strike was filed. I think they phrased it as a motion to strike. I think that's kind of probably not the best language. When they probably should have filed a motion entitled Challenge of Criminal History or some other designation like that, as is required by State v. Key, which requires these issues to be raised before trial.
But that really just is a motion to dismiss the felony charge, because that's what's hanging here. You can't really, I mean, there isn't any other purpose to what the defendant's trying to do.
Right. They could amend the charge to a misdemeanor if the state wanted to, but they can still prosecute for DUI in this case, Judge. I'm
just focused on the jurisdictional aspect of this, and it just seems to me that we're talking about the same thing. And so the court ought to have the state ought to be able to challenge the issue that you raised and won on at the district court level. Why am I wrong about that?
Judge, I don't think you're wrong. I think the state at the close of the case, if this case gets, if there is a conviction in this case, the state could file a motion to correct legal sentence. I think that's the proper avenue for challenging the felony or misdemeanor designation in similar situations like this.
What happens if there's a jury of 6 because it was amended to a misdemeanor, and then you're trying to correct that illegal sentence? I mean, why is that the right remedy? Does that implicate jury trial rights, your proposed alternative?
Judge, I think that is our best argument, Judge. I think that the big issue here is that jurisdiction is a idea that is granted by statute, and the statute simply does not address that refusal to consider priors in a DUI case, Judge. Had that 3603 listed out substantially impaired ability to prosecute a felony, I think we'd be fine. There'd be no jurisdictional issue, but I think that's the problem I feel like the state runs into on this, Judge. Moving on to the merits of this, we believe that the 2018 version of the DUI statute plainly and unambiguously requires an elements-based comparison of prior DUI convictions to determine whether or not they're comparable. I believe that Myers was correctly decided on this point, and we also believe that Mejia must be overturned. And we have 2 reasons for that. First of all, that Myers' interpretation of 1567 is not ambiguous, as comparable was in Wettrick. The second reason is that Myers offers a clear path moving forward, and that's not the case with Mejia. So starting off here with 1567J1, I think that we can probably all agree that whether or not a prior is considered a DWI, DUI, OUI, OWI, anything like that, I feel like that's satisfies one, and that's what we have here. We would concede that a prior would count under J1. Under J2, the state has already conceded that an elements-based comparison requires interpretation of 577-010 as the Court of Appeals did in Stanley because of the broader definition of DUI in Missouri. With 1567J3, whether or not the offense prohibits similar conduct, Judge, we think that this court is duty bound to interpret statutes in a constitutional manner. The only way to interpret this one in a constitutional manner is that similar conduct must mean identical to or narrower than. And we can get there not only through Wettrick, but we can also get there through appellate interpretation in Stanley, Dickey, Apprendi, and Mathis. Because we know that the courts below cannot go through it and look at conduct, and that's what this statute specifically asks for.
Why is there a constitutional problem with those three factors?
The constitutional problem lies in the fact that it's asking courts to go back and look at what actually happened when it asked courts to look at conduct.
Well, it's the conduct in the statutory language, right?
That's not the way I read J3, Judge. It's whether or not the offense has similar or prohibits similar conduct. It should probably read whether or not the out of jurisdiction offense is similar in nature or has similar elements or something like that. But it doesn't say that. It asks judges to look at conduct. And the focus on the conduct.
Isn't it asking judges to look at the conduct prohibited? Conduct prohibited is different from conduct that the evidence in this particular case demonstrated. At least that's the state's position, I think, is that because the statute uses not just the word conduct, but it's conduct prohibited, that draws you directly into the language of the statute. And it doesn't draw you into the underlying facts.
Right, Justice. I understand that argument, and we think that even if you're looking at conduct prohibited, or even if we're interpreting that as being an elements-based comparison, we still think that the elements-based comparison must still be identical to or narrower than, because that's the way the U.S. Constitution. U.S. constitutional analysis goes on these issues. I don't see that there's any reason why our DUI statute shouldn't also follow that. Furthermore, we ask that the judges compare the elements, do an elements-based comparison. So when we ask those judges to make an elements-based comparison, we're doing exactly what we've asked them to do in Stanley. We're asking them to do exactly what we've asked them to do in Wettrick, Mathis, DeCom, all those cases, Judge. But I think that's probably a reasonable analysis, because you do have to interpret the statute in a way that renders it constitutional, and that would render it constitutional. But that being said, Mathis still requires us that these priors must not be broader than the comparable Kansas crime. I think about, Missouri including a wet reckless DUI, which is, a much lower standard, which is basically just poor driving with alcohol in your system. If that was a conviction, they're probably looking at something like that that would be excluded from consideration on this. But the advantage of taking up the Myers position in this one, as opposed to the Mejia position on this one, is that Myers offers a very clear path moving forward. We all know that the judges will be ordered to look at an elements-based comparison, that the out-of-state priors that are not identical to or narrower than cannot be used to score on a criminal history worksheet.
Counsel, I'm sorry to interrupt, but I just, again, trying to get clarity on your position. It sounds like your argument is that the 2018 amendments really didn't change Wettrick at all. Is that right? By their plain language.
I think so, Judge. I think that's correct. I think that.
So what was the purpose of the 2018 amendments?
So when I read the 2018 amendments, that requires an out-of-state elements-based comparison, frankly, I think that codifies Stanley. With the similar conduct provision under J3, I do think that codifies Wettrick. Now, I understand that the state has gone to the preamble on this one, but frankly, Judge, that's not in the statute. If we look at the four corners of this law, it's clear what we were supposed to do. It's clear that we were supposed to compare the out-of-state prior elements, and I think it's also clear that those elements cannot be more broad if we are to interpret this statute in a constitutional manner.
Can I draw your attention, as my last question, to before Wettrick, when this court decided the Vandervoort case, and this court in that case said that the word comparable doesn't mean identical. Can we look at the contradiction between Vandervoort and Wettrick and see ambiguity in the statute?
So this hits at the heart of my major issue with this case in Mejia. In that one sense, they use Wettrick to say the comparable's ambiguous, whereas at the time when Wettrick was considering the Kansas Sentencing Guidelines Act, there was no definition of comparable. So comparable was ambiguous. But at the time when we're considering this one, there is a definition of comparable under 1567J 1 through 3. Because of that, I think that the state has taken advantage of its best parts of Wettrick and ignoring the fact that 1567J tells us exactly what we were supposed to be doing. So, Judge, for those reasons, I don't think that we can consider other cases that have said comparable is ambiguous.
Well, and so you don't think, you would disagree with the idea that the legislature in J3 was actually trying to codify the holding in Vandervoort. And the Vandervoort holding, just to remind everyone, is that comparable means, quote, closest approximation.
I don't think so, Judge. I think that what that means is that the only constitutional interpretation that we can take of J3 is similar to that Wettrick analysis. And I use that Wettrick analysis. To call it a Wettrick analysis is not exactly even accurate as well, Judge. Wettrick was just simplifying the federal case law on considering out-of-state priors. And that case law was, cases like Shepard and DeCom, Mathis, Johnson, and those line of cases.
So I didn't mean to interrupt you, but are you then suggesting that you would strike J3 as unconstitutional, or at least not give it meaning under your elements approach?
Judge, I'm not asking that we strike J3. I think that the courts are required to interpret the statutes in a constitutional manner. And to interpret it in a constitutional manner, that's the identical to or narrower than test, which is an interesting question, because essentially what the state is asking us to do is ignore J2 by focusing on J3. They're asking us to ignore J2. And even though they've acknowledged that under J2, Stanley applies and the out-of-state priors on this case are not counted. Further, it adds a lot of other problems that Mejia brought up with its example of the Arizona priors. And Mejia creates a situation where the whole J section is superfluous. We know that the legislature does not enact superfluous legislation because under Mejia, it's identical to, broader than, and narrower than. So if we were to take Mejia's interpretation, every other state's prior DUI convictions would count. And that's just not what the statute says. The statute requires us to do an elements-based analysis. For those reasons, Judge, I see that my time is up, but if there's no more questions, I think that this court must find that it does not have jurisdiction to hear the merits of this case. If the court does find that it does have jurisdiction, it must reject Mejia. Find the language of 8-1567 is clear and unambiguous. Thank you.
There are other questions? Mr. Gonteski, you reserve 3 minutes of rebuttal.
Thank you, Your Honor. Just at the outset, in the event that this court does find that it does not have jurisdiction and that the Court of Appeals did not have jurisdiction to take this appeal, the net result would be to unzip and unwind what happened at the Court of Appeals in this case. And the published opinion at the Court of Appeals would then, obviously, that would be reversed. What that would leave in the state of Kansas would be Mejia being the controlling law, because Mejia says those prior convictions count. Mejia was a published opinion by the Court of Appeals. Its petition for review with this court was denied. So what we would be, the net result would be, we would be left with what the state is seeking ultimately in this case, in the event this court finds no jurisdiction. But I do want to touch on a couple of points that Mr. Stolte made. Number one being, he has indicated a couple of times that the state has conceded that Stanley controls over the elements-based comparison in subsection J2. I concede not that Stanley controls. I concede that a pure elements-based comparison does show that the Missouri law is broader than the Kansas law. That can't be denied. The Missouri law does prohibit more conduct than the Kansas law. But when taken in total and examined all those factors in a grouping, it becomes clear that the Kansas statute intends to encompass and capture those Missouri prior offenses. Mr. Stolte also made the point that the 2018 amendments by the legislature were their attempt to codify Wettrick and Stanley. There's no need to codify Wettrick and Stanley. Wettrick and Stanley at the time of these amendments were the law. This court had pronounced as much. So when Wettrick and Stanley had set forth that the state could not use Missouri prior offenses, the legislature needed to do nothing if it sought to firm up the rule that Kansas courts could not use Missouri prior convictions. The legislature
Mr. Gonteski, I just got a question before you finish up. What if the conduct that gave rise to the Missouri conviction, what the conduct was a part of the statute that was broader than what the Kansas statute permits? You would say that would still count?
Absolutely, it would still count.
And what's the rationale for that? I mean, we don't recognize that as a DUI in Kansas, plain and simple.
We don't.
So why would it count?
The rationale is that when this court decided in Stanley and Wettrick that we could only count identical to or narrower than out of jurisdiction offenses, the legislature responded to that. There's no constitutional infirmity with including whatever prior convictions the legislature wants. The legislature could have said, if you've ever been convicted of murder, then your DUI is automatically a felony. If you've ever been convicted of shoplifting, then your DUI is a felony. It doesn't have to be the same statute. But here what we have is the legislature responding to Wettrick and saying, we're going to look at the name, we're going to look at the elements, but also we're going to ask, does that out of jurisdiction statute prohibit similar conduct to the closest approximate Kansas one? So
counsel, since you're out of time, I'll jump in and just a follow up to Justice Rosen's question. I think in similar vein, let's say we agree with you and conclude that subsection J does in fact enable courts to count out-of-state offenses that are broader than, and whether you want to use the Vandervoort language of closest approximation or the statute's language of similar, I guess I have a practical question, which is this just a gut feeling by judges? I mean, earlier you described this as a Breyer-esque balancing test. And as you know, Breyer's balancing tests have often been criticized for just simply meaning whatever the judge thinks. Is there any objective standard by which judges are supposed to apply this test that you're asking us to adopt?
I believe, Justice Stiegel, that the objective test is the legal one that does nothing to look at the facts of an out-of-state prior, but only look at the conduct that is prohibited. And it does wind us back to and take us back to the Vandervoort days, which were not constitutionally infirm in the state's position.
For purposes of my question, let's concede it's not constitutionally infirm. I'm just, what you're telling me, it sounds like, is it really is just, do the judges think that it's similar enough? And there's just really, that's a highly subjective standard. Would you agree?
I would agree there's subjectivity there. I would agree with that. And that is the way that, and again, even if there's subjectivity to it, even if there are judges that would find either way, that in and of itself does not make the statute impermissible or unconstitutional. And it doesn't require this court to find that the defendant's controlling language of identical to or narrower must control. But if we're going to do so, if we're going to find that that's in too subjective of a test, essentially what we'd be finding would be it's because it's ambiguous. If it's subjective, it's because the terms are not sufficiently clear. If they're not sufficiently clear, this court should look immediately to the legislative intent, which is rife with clear indications that, at least in the context of this case, where we're examining the Missouri statute, the legislature intended to capture the Missouri prior offenses. So in the event that there's too much subjectivity there, that would equate to the statute being ambiguous, which gets us to the legislative intent angle. I don't believe as though it is so ambiguous to necessitate as much, but in the event that this court finds that subjectivity area too concerning, that's what would get us there. A defendant, nevertheless, would still have an ability to challenge that district court's finding of that prior offense by appealing it up. The state would not have the same ability to appeal up, as was noted earlier, in the event that the district court said, proceed state with your misdemeanor because I've stricken all the priors. The state would be left powerless in that scenario. We can't file a motion to correct an illegal sentence if a jury of 6 convicts a defendant of a misdemeanor. We're left with nothing after that. So recognizing my time is up. Thank you very much for your time. I'd ask that this court reverse the Myers decision and find that in the context of this case, Missouri prior offenses do constitute prior DUI convictions under the 2018 amendments.
Thank you to both counsel for your arguments this morning. The court will take this appeal under advisement, and we are now in recess until 11 a.m.